The Bhopal gas tragedy case summary. Okay, on the night of December 2nd in 1984, one of the world's worst industrial disasters happened in Bhopal, India. A toxic gas called methyl isonate or MIC leaked from a pesticide plant run by Union Carbide India Limited. There were about 40 tons of gas escaped into the air, spreading over nearby neighborhoods. At first, around 4,000 people reported dead, but in the following days, the number kept on growing. So, in total, over 22,000 people lost their lives, and more than 500 people were injured. There were many survivors still suffers from health problems, and some children were born with birth defects. Why did this happen? So there were several safety systems like the refrigeration unit, flat tower, and the gas scrubber were not working properly. So the gas tank was overfilled and the water may have entered the tank by accident and causing a deadly chemical reaction. So Union Carbide claimed that it was a sabotage. But however, others claim that it was caused by a poor maintenance and lack of safety measures. So the legal battles lasted for years. So in 1989, Union Carbide paid $470 million in a settlement with the Indian government. But many people felt this amount was not enough. So the court said that companies dealing with dangerous chemicals must take full responsibility no matter what caused the accident. So the Bhopal gas tragedy is a reminder of how important the safety are, the regulation, and the corporate responsibility are, especially when the lives are at stake. Next is the key parties involved. The Bhopal gas tragedy involved the several major players. Union Carbide Corporation, called as UCC, a US-based company, owned most of Union Carbide India Limited (UCIL), which operated the pesticide plant. After the disaster, UCC denied the responsibility, blaming the Indian unit and later suggesting sabotage by a worker. Warren Anderson, UCC CEO, was briefly arrested in India but released and never returned to face trial. His escape caused a public outrage. So Indian government led the legal battle and helped settle the case in 1989 for $470 million. A deal may saw as unfair. So agencies like the CBI investigated, but some believe key evidence was hidden and that victims were not properly compensated. There were about 500,000 people were affected, many still suffering still today, and the victim groups continue to demand justice and accountability. In 2001, Dow Chemical bought UCC but claimed no responsibility for the tragedy, adding to the legal and moral debate that still continues.
Good day, Senior Council. I seek to present a brief on the Bhopal gas strategy, which occurred in December 1984 in Bhopal, India, involving Union Carbide Corporation (UCC) and its Indian subsidiary Union Carbide India Limited (UCIL). This incident resulted in significant loss of life and long-term health consequences for thousands. Investigation revealed multiple instances of negligence on the part of the company. Safety standards were severely lacking. Employees at the plant were not adequately trained in handling of methyl isocyanate, a highly toxic chemical, nor were they aware of the emergency protocols required to manage leaks or chemical reactions. Further, senior management allegedly ignored repeated warnings about the plant's condition. Evidence suggests that UCC officials chose to remain willfully ignorant of the serious hazards present. After the leak, there was a delay in disclosing the identity and effects of the chemicals involved, which severely hindered medical treatment and increased fatalities. There were clear violations of both environmental and industrial safety regulations. The plant lacked critical safety infrastructure, such as functional alarm system and evacuation procedure. Additionally, the design and maintenance of the facility did not meet the required standard for handling hazardous substances. The immediate impact was catastrophic. Thousands died and over 500,000 individuals were affected. Many continue to suffer from chronic illness such as respiratory problems. Legally, UCC was held liable and a civil settlement of 470 million USD was reached. However, this amount has been widely criticized as insufficient. Efforts to extradite the UCC chairman and impose criminal liability have faced significant hurdles. In conclusion, Bhopal disaster demonstrates gross corporate negligence, regulatory failure, and lack of corporate accountability. It serves as a precedent for the urgent need to strengthen industrial safety laws, enforce environmental protection, and ensure transnational cooperation are held to account.
Now, let us move on to the legal and ethical issue. From the Bhopal incident, we were exposed to a very serious legal and ethical issue where both of the company, which is the UCIL and the Union Carbide, failed to warn the local people about the dangers of the gas. First. Second, they failed to and ignored basic safety measures such as cooling system and emergency plan. It is because they were prioritizing their profit, and because of this priority, they caused over 15,000 people to lose their life and hundreds of thousands people suffered injuries from the Bhopal. Secondly, it exposed a very big flaws in international law. The Bhopal tragedy revealed how hard it is to hold multinational corporations accountable for disaster that they cause. Despite Union Carbide in the US was the majority shareholder in its Indian subsidiary, which is UCIL, legal efforts to hold the parent company responsible were failed. The US court dismissed the lawsuits on the ground of forum non-convenient, pushing the case to the Indian court. And when the case is pushed to the Indian court, the justice move very slowly, and the compensation to the victims of the incident was very minimal. Last but not least, the Bhopal incident also exposed to a very serious violation of the international human rights standard. It breached the fundamental rights to life, fundamental right to health, and clean environment as guaranteed by the International Covenant on Economics, Social, Cultural Rights, and Universal Declaration of Human Rights. Thousands suffered from both immediate and long-term health costs by the toxic methyl isocyanide gas leak. This disaster showed a blatant disregard for human life, violating the right to life protected under the Article 21 of the Indian Constitution and the international law. Even decades later, survivors continue to face health problems, environmental damage, and loss of their livelihood.
Good morning, Senior Counsel. Thank you for giving me the opportunity to present this matter. And I have reviewed the Bhopal gas explosion case, which tragically stands as most of the catastrophic industrial disaster in the history. And it is clear exposed the systematic failure in the corporate governance and the gross negligence committed by the Union Carbide Corporation through its Indian subsidiary, the Union Carbide India Limited. And from an assessment, it is evident that the director and the senior executive have involved to fail to uphold their fiduciary duties, not only to the shareholders but also to the employees and to the public. These individuals were entrusted with ensuring that the company operated in the best interests, which include providing the safe working environment and complying with the environmental and safety regulation. And however, prior to the disaster, the company has significantly reduced their maintenance budgets, and knowingly, this increasing the operational risk towards the employees. Reports of leaking valve and faulty equipment have been raised and reported to the directors, but rather than taking corrective action, the director chose to ignore this warning and maintain the production level to avoid their profit to be reduced. Furthermore, the workers were not given the adequate safety training despite the hazardous nature of their work environment. And these failures has amounted to a clear breach of Section 213 of the Companies Act 2016, where the directors are required to exercise their reasonable care, skill, and diligence. Additionally, by prioritizing profits over the safety, they have acted in the bad faith, which contravenes Section 218 of the same Act, which is the Companies Act 2016, which this section had required the directors to act honestly in the company's best interest. And apart from the corporate law breaches from the perspective of company law, there's also the clear violation of Operational Safety and Health Act 1994. Under Section 15, the employers have a duty to provide a safe workplace to the employee. And UCIL failures to prevent the gas leaks and protect its workers is a direct breach of this section. Under Section 17 of the same Act, we have seen that the director may be held personally liable if it is found that they had consented to it and were complicit in this kind of violation, which in this case appears strongly as supported by the facts. And given this finding, I believe that this proposal is both proper and necessary, and not only hold the responsible parties accountable, but also serve as a step toward justice to the victim. And I believe that it is adequate course of action to ensure that the director who fail in their duties are brought to face the consequence of their decisions. Thank you, Senior Counsel.
Now, let's talk about how we can prevent another Bhopal explosion from happening again in the future. Let's learn about from the past to ensure the banana not fruit twice. So, Bhopal gas disaster still remain heavily contaminated with buried and scattered toxic chemical waste. There are still many poisonous substances, including heavy metals, that are still leaching into groundwater and soil, poisoning ongoing environment and health risks. So, how can we counter this? Our recommendation is that we make some effort to clean the site. Urgent cleanup is very overdue and should be led by an international recognized environmental authority, for example, United Nations Environment Programme. Initial decontamination must focus on 30 plus tons of underground toxic waste before broader cleanup can begin to ease the process of the cleanup. A comprehensive environmental audit is required to assess pollution, spread and concentration. Regular transparent soil and water testing must be conducted with results freely accessible in a multiple language. Biomeditation, which is a process of using plants, can be used where it is viable. Otherwise, excavation and offsite disposal will be necessary. A permanent and environmental monitoring station should be established near the site to track soil, air and water quality of the contaminated site. This station will support early warning system, public education and ongoing data collection for future disaster prevention. Environment Surveillance Center, which is ESC in Bhopal, is a step toward real-time environmental monitoring and impact management. National Environment Policy 2006 emphasized the need for intensified monitoring infrastructure, online data, transparency.
In conclusion, the Bhopal gas tragedy shows what happens when corporate greed, weak laws, and global inaction collide. Decades later, victims still suffer and the land remains toxic. Union Carbide, Dow Chemical, and the government fail. We need full cleanup, strong global laws, and true justice so things like this will never happen again.